Good to see everybody out here. I'm Matt Baker, editor-in-chief of the Journal of Energy, Climate, and the Environment, and we are very excited about this really phenomenal panel that we're having here in the fall, second annual panel for our journal. A few people that we definitely should thank, our faculty advisor, Joe Fraley, and kind of our unofficial faculty advisor, Professor Carr, have done a lot of work on this. Also, the ladies in faculty service, Wendy Rice, has been incredibly helpful. And really the individual that's pulled everything together today, Anthony Rossi, has done a great job and put in a lot of effort. And all of those people definitely deserve to be recognized. A few things. This is a panel that will last 2 hours, but we know that people will be coming in and out. I just want to make sure the panelists know, I think around 1 o'clock we have a lot of students who do have a major class, so there probably will be some people that leave around 1 o'clock. But there will also probably be some people coming in, so feel free to come and go. Just try to come and go quietly. If you could put your cell phones on silent, vibrate, anything like that, that would be good. And with that, I'm going to introduce the moderator of our panel, who we're very excited to have, Dr. Williams from the undergrad side. Dr. Williams has been a professor here for probably about 25, 30 years, something like that, in the physics department. And he is also a former provost at the university and also a former head of the Washington in the Department of Physics and Engineering. So with that, I'll turn it over to Dr. Williams and let him introduce our panelists here. Thanks.
Let me welcome you all here. It's good to see a session be filled up with folks. And thanks to Anthony and to Matt for inviting me to kind of bask in the reflected glory of three pretty extraordinary speakers you will hear from. They've got a very long, impressive list of credentials, and I have taken the liberty of compressing them a bit so you'll hear less about them and more from them today, and I hope I've done no damage to their credentials by doing so. I'm going to introduce each of the three at the beginning, and then the talks, their presentations will follow. First, Dr. Charles Ferguson, Center, is president of the Federation of American Scientists, an independent, nonpartisan organization providing analysis of and policy recommendations regarding national and international security issues involving science and technology. Prior to joining the Federation of American Scientists in January 2010, he was with the Council on Foreign Relations, where he specialized in arms control, climate change, energy policy, and nuclear and radiological terrorism. There, he also served as the project director of the Independent Task Force on U.S. Nuclear Weapons Policy. He has also worked with the Monterey Institute's Center for Nonproliferation Studies as scientist in residence. He co-authored the book, The Four Faces of Nuclear Terrorism, and was co-author of the report, Commercial Radioactive Sources, Surveying the Security Risks. This latter report received the Landauer Lecture Award from the Health Physics Society. Dr. Ferguson graduated with distinction from the U.S. Naval Academy, served as a submarine officer, studied nuclear engineering at the Naval Nuclear Power School, and earned the MA and PhD in physics from Boston University. He has consulted with the Oak Ridge and Sandia National Laboratories and the NSA. For 2 years, he worked in the Department of State, helping develop nuclear safety and security policies. In October 2008, Wired magazine named Dr. Ferguson one of the 15 people the next president should listen to. Today, Dr. Ferguson will be discussing the role of third-party input in the U.S. Dr. Ferguson.
Or you want to do the others first? Okay.
That was an applause line. Professor Albert Carr on the left, and you know, practices law in association with Duane Morris, LLP, a Washington, D.C. law firm, and serves as professor of practice here at the Washington Lee School of Law. His practice focuses on energy law, in particular nuclear energy and nuclear licensing. He frequently represents utilities seeking NRC licenses for the operation of nuclear power plants and advises regarding compliance issues. He also represents clients in regulatory issues involving FERC, the Federal Energy Regulatory Commission. He spent 20 years with the legal departments of Duke Power Company and Duke Energy Corporation and was lead counsel for Duke Power in NRC and FERC regulatory matters. Prior to that, he was in private practice in Washington, D.C., representing clients before FERC and NRC in energy regulatory issues. He served with the Federal Power Commission and the U.S. Atomic Energy Commission. Presently, he is completing a chapter on the future of nuclear power in the United States that will be part of a volume edited by the Federation of American Scientists and Washington Lee University to be published early in 2012. Professor Carr received degrees from the Virginia Military Institute and the Washington and Lee School of Law. He's a veteran of the United States Marine Corps. Professor Carr will be discussing the U.S. nuclear regulatory regime. Professor Carr. And third on the right, Professor Carl Goodman is a retired partner in the firm of Jones, Day, Revis, and Pogue. He is currently an adjunct professor of law at Georgetown University and an international legal consultant. He began his career in the U.S. Department of Justice and was special assistant to the Assistant Attorney General for the Civil Division. He then served in the Civil Division's Office of Alien Property and later in the Department of State, the Environmental Protection Agency, and as General Counsel of the Civil Service Commission. He joined the firm of Surrey and Morse in New York and developed a Japan-related practice. Retiring as a partner in Jones Day in 1991, he became a professor of Anglo-American law at Hiroshima University in Japan. Returning to the U.S. in 1995, he has since served as consultant to numerous Japanese companies and their American subsidiaries. He has lectured at a variety of Japanese law schools, was a Fulbright lecturer at Tokyo University Faculty of Law, has served visiting appointments at Chuo University in Tokyo and Temple University, Tokyo. His book, The Rule of Law in Japan, A Comparative Analysis, was published in January 2003 by Kluwer Law International. A revised second edition of that book was published in 2008. In September 2004, Oceana Publications published his book, Justice and Civil Procedure in Japan. Both books have been extensively cited in portions of Civil Procedure book reprinted in a text on comparative civil procedure. He was recipient of the Charles Fahey Distinguished Adjunct Professor Award, Georgetown University Law Center in 2005. Professor Goodman received his JD from the Brooklyn Law School and his LLM from Georgetown University. Today he will be discussing the Japanese regulatory regime. So we will be, we will have all three presentations at the end. There should be time for some questions. So we'll begin with Dr. First.
Well, thank you very much, Dr. Williams. It's a great pleasure to be here at Washington and Lee University, and I'm finally discovering law school. I've been here many times, worked with my dear friend and colleague, Dr. Frank Settle, who's sitting there in the front row. Had an affiliation with Washington Lee and Professor Settle, I guess going back now about 7 years. I think we met. He was actually a student of mine, believe it or not. So I was teaching the summer course, and I was to professors teaching about non-proliferation issues, and I was giving a lecture about how nuclear weapons work and a nuclear fuel cycle. And here's this fellow sitting in the audience, and then raised his hand, and he asked me a question about uranium hexafluoride. And I'm thinking, wow, he really knows his stuff. Well, it turns out he's a professor of chemistry, so he should know his stuff. And so we hit it off from there, and it's been a great pleasure to work with him and various colleagues here at Washington Lee. My deceased father, I think, would be proud of me today. I finally made it to a law school. He wanted me to be a lawyer, and I disappointed him. I decided, as you heard from Dr. Williams, to become a scientist, and I also got training as a nuclear engineer. And I also am an adjunct professor at Georgetown University, not the law school, but the School of Foreign Service. And I tell my students at the beginning of the semester. Most of them are political scientists by training. And I said, I'm practicing political science without a license. So I will not attempt to practice law without a license today. I feel a little bit out of my league. So what I'm instead going to do is just walk you through some of my thoughts, observations about various third parties and their influence in regulatory practice or the formation of legislation dealing with nuclear power and the control of nuclear technology domestically and internationally. So I'll introduce who the third parties are, and we'll get into various means that they could influence these processes. I'll present a few historical examples, and I think they'll complement nicely what you'll hear from Professor Carr right after me. And then I'll discuss a few recent third-party activities that I think that are worth reviewing right now, some very active cases. And then just a few thoughts at the very end in terms of comparison between what I've seen in the U.S. versus what I've seen in Japan. And I don't have nearly extensive experience in Japan as Professor Goodman, but I've been there a number of times and talked to a lot of Japanese colleagues, so hopefully I can add something to that as well. So who are these third parties? And this is not necessarily an exhaustive list, but I think this is pretty representative of the different types of groups. Since I am a scientist and I'm president of a scientific think tank, I was arrogant enough to put the scientist groups up there at the top, but there's a reason for that, as you'll see when we get into one of the first historical examples. And then it's very important to also talk about another group that I'm familiar with and I had some training with. It's the nuclear navy. And I'll talk about the development of the first designs of nuclear reactors and how that's influenced both the United States and Japan. And then talk a little bit about this organization called the Institute for Nuclear Power Operations, why they're important. Touch on environmental groups' influence. Talk a bit about policy think tanks, and I've worked for a few of those. And then just I'll mention here at the beginning, citizens groups and Nuclear Energy Institute. I won't really say too much about those two in this talk for the interest of time, but it's important to keep in mind that, yes, citizen groups can intervene in the process, and I think Professor Carr will probably talk more about that than I will. And the Nuclear Energy Institute, which is a lobbying organization representing the nuclear power industry. They also have clients from and other energy industries as well, and they're based in Washington, D.C., and they're very influential. If you listen to NPR, you probably heard their ad. If you open up, I don't know if any of you read newspapers anymore, but I still get a newspaper. I get the Washington Post every morning. Sometimes they'll run ads in the Post, and you'll see ads for nuclear power is great because it's clean energy because it doesn't emit greenhouse gases from an operating nuclear power plant. So you're probably familiar, at least somewhat, of what NEI has been doing in their position. There are various ways that these groups can influence the regulatory process and legislation. They can obviously publish reports and articles, fact sheets, opinion articles, op-eds, etc. They can actually help in drafting legislation or give congressional testimonies. I myself have given a few congressional testimonies. I spoke last year to the House Science and Technology Committee in May, and I was asked to be the non-governmental representative on the panel, offering my views on the Obama administration's nuclear energy roadmap. These groups can interact with the press, the news media, TV, internet, radio, print publications that get their views known. And I've already mentioned ads that groups like NEI can run. They can meet with executive branch officials in addition to legislative branch officials. These could be public meetings, they could be conferences like we have here today, or they can be behind closed doors. But Professor Settle and I had a very active program at the Council on Foreign Relations for about 3 or 4 years. We had a roundtable series. We had about 6 meetings a year, and we had a couple of major workshops, one here at Washington Lee and one at the Council on Foreign Relations. So that's another way that these groups can have influence. And finally, it's worth mentioning lawsuits. And I'll talk a little bit about NEPA And since I'm a lawyer, I won't pretend I really know that act, but it's important to bring it up. So the first speaker, maybe Professor Carr, Professor Goodman, can talk a little bit more about NEPA and the National Environment Policy Act. Okay. Well, let's go back to the very beginning and actually go back to the founding of the organization that I represent, Federation of American Scientists. Back in the Manhattan Project, built the first atomic bombs. There are what they're called the atomic scientists. Now we know there's nuclear scientists, nuclear weapon scientists, then it was atomic bombs, now they're nuclear bombs. And so these scientists were very concerned about this awesome technology that had been unleashed at Hiroshima and Nagasaki. So a number of them got together and they formed the Federation of Atomic Scientists in late 1945. Early 1946, they rebranded themselves as the Federation of American Scientists, same acronym but slightly different name. And in 1946, they put a lot of effort into this act. There was then a bill, the McMahon Bill, which became the Mann Act 1946, Public Law 585. And this established the Atomic Energy Commission, the AEC, where Professor Carr used to work. And the important point here is that this was a civilian-run government agency. Remember, the Manhattan Project, military control, you had these scientists who were inducted into this weapons program, and it's dual-use technology. You can use that for either making weapons, or you can use nuclear energy to fuel reactors and do other kind of peaceful things, create medicine, isotopes, those kinds of activities. And so it's very important for these scientists to make sure that this was a civilian-run agency. And we'll talk a bit about later on how that evolved, and I know Professor Carr will have more to say about that as well. Also in 1946, there was a very important report that came out that had a lot of influence, but not as much as the creators of the report really hoped for. This report's known as the Acheson-Lilienthal report, named after two political leaders who were got their names on the report, but it was really the scientists really deserve a lot of credit for writing the report. And so Robert Oppenheimer, here is a very pensive-looking man, had a lot of things laying on his mind, nuclear war and such, and very other things were and then lost his security clearance, I think, by the time this photo was taken. He was asked, he was the scientific director of the Manhattan Project, he was asked to be the lead drafter of this report. And I won't go into it in a lot of detail, but just hit some of the main salient points. So it had a lot of input from the leading atomic scientists, and they realized that any system of national control of nuclear technologies could lead to proliferation into weapons programs. A system of national control, in their view, was not adequate. So they advocated for international control of the fuel cycle. And we're still trying to push that boulder up the mountain, I guess, like Sisyphus, even to this day. It's like every 10 years or so, there's new proposals coming out that are very much echoes of this report from 1946. They also looked at the technical question, could you denature the fissile material so it couldn't be used in weapons? And they convinced themselves that there's really no kind of technical steps they could take to make it something proliferation-proof. You can try to make technologies more proliferation-resistant, but you couldn't make it proliferation-proof. This report also called for the creation of an Atomic Energy Development Authority, which later on morphed into President Eisenhower. He gave his famous Atoms for Peace speech in December 1953. He called for a similar type of agency that became the International Atomic Energy Agency that was created in 1957. So you can see these group of scientists and political experts were ahead of the curve. At the very beginning, they were thinking that we needed an international body. Well, Bernard Baruch took this report, he altered it, he took it to the United Nations. So the first major resolution at the UN was about control of nuclear technologies and nuclear disarmament, and it fell flat. And I don't have time to really get into why it fell flat, but it's a very interesting historical thing that's worth reviewing if you have time. So let's fast forward a few decades to the 1970s, a very crucial decade when the Atomic Energy Commission was disbanded or transformed into two separate agencies. Because it was realized that if you have the same agency that is promoting nuclear power and overseeing or regulating nuclear power, you have a potential conflict of interest. So remember, the innovation back in the mid-40s was a civilian control agency, but after 25 years or so of that, they realized, okay, we need to evolve this further. As nuclear power began to flourish commercially and more civilian nuclear plants were being created, they realized to ensure proper oversight, they needed to form the Nuclear Regulatory Commission, which is the regulatory body, and then they formed the promotional body, which was the Energy Research Development Agency Administration, ERDA was the acronym, and that soon became what we now have as the Department of Energy. Okay, I'm going to skip back. I'm not going in historical order necessarily here. I'm going to skip back a bit to the 1950s and talk a little bit about how the role of the nuclear navy, development of the first nuclear-powered warships, especially submarines, influenced the development of nuclear power in the United States, Japan, and several other countries. You may have heard of Albert Rickover. I missed meeting him by a few years. He had retired before I went through the interview process at Naval Reactors in Washington. I was interviewed by a successor. And he really left his mark on the U.S. nuclear Navy, even to this day. He strongly emphasized that they needed to build a standard of excellence that's just drilled in to people in the nuclear Navy from the first day you're involved in that service. And so this group of people, and there are a number of them, there are thousands that have been through the program over the decades, they formed a body of people who can then go into the commercial sector, either work in the industry running a nuclear power plant, or get involved with the regulatory agency and adopt that standard of excellence from the naval nuclear power into the commercial sector. Well, a little bit about the Fukushima Daiichi type of plant design. And not all the reactors there are the same, but this is very much a schematic or kind of a cartoon of the main points of that reactor design. And I'm not going to have time to teach all this to you, but some points I want to emphasize here is look at this relatively small volume here. So you have right here, this shape right here, you see these rod-like stuff and the control rods and the fuel material. Here's the reactor core, and it's in this reactor pressure vessel, which is made of very strong material. It's designed not to rupture unless it's under very high pressure. And surrounding that is what's known as the primary containment structure, which is also very strong. You don't want that to be breached. If it is, then there's a pathway for radioactive materials to go out to the environment. And the secondary containment building is not nearly as strong as the primary containment building. It's almost like the metal in a kind of a garden shed. So if you have hydrogen leakage and hydrogen explosion, it can blow a hole right through the secondary containment structure. And that's what we saw with a number of the reactors at Fukushima Daiichi. So why did they choose this particular design? Why such a small volume to take up the steam that might be produced when there's a loss of coolant accident? Well, think back to a nuclear submarine. You have a very tight volume there. You've got to squeeze that nuclear power plant into the confines of a submarine. So this is a design that evolved from submarine technology. So if we hadn't had a nuclear navy, if the technology had developed differently, we might not have this particular design operating in Japan and 23 other types of reactors in the United States. So it's also, you keep in mind the importance of technology development history. Speaking of history, now I'm going to skip to the 1970s again. In the 1970s, 1979. And this is not too far from where I grew up. I grew up in western Pennsylvania, not too far from 3 Mile Island. And so I date myself, I think I was a freshman in high school when this happened. So I very much, this is in my memory banks. This accident was a wake-up call of sorts, but it wasn't that bad. Yes, there was a partial meltdown. Yes, it caused a lot of economic damage, but it didn't spell the death knell of nuclear power in the United States. Nuclear power was having troubles prior to the accident for a number of other reasons that I won't get into right now. But the important point here is that this was a wake-up call for the operation of the plants. Prior to the accident, nuclear power in the United States was not at its potential. It was, if you look at the operating history of the plants, probably they weren't operating the plants more than 60% of the time at maximum power. So they weren't getting their money's worth out of the reactors, for one thing. And the performance was very low. And so once the accident happened, some former naval nuclear people got together and said, we can do a much better job than this. So they formed this industry watchdog group, INPO, the Institute for Nuclear Power Operations, based in Atlanta. And they went around and they did confidential reviews of all the nuclear plants. And every year they got together, they got all the CEOs of the nuclear plants in the room, and they said, here's how you rank. So you guys, you're in the top third, attaboy, attagirl, and then you're in the bottom third, you can do a much better job than this. So there's a lot of peer pressure. So it was a way, you can't do self-regulation. You still need that independent, strong regulatory body Professor Carr will talk about. But this is a way of a third-party way of the industry itself trying to raise the standard of excellence. And overall, they've done a very good job. Okay, now shifting gears to another set of groups, environmental groups. And I want to emphasize they're not monolithic in their views and how they do things. They're not all anti-nuclear. And even some organizations that have anti-nuclear people in them, there are others in the organization that might be kind of pro-nuclear or might have a more nuanced view of nuclear power. So up at the top, I've listed Natural Resources Defense Council. Not the oldest environmental group in the country by any means. The Sierra Club's been around a lot longer. NRDC's been around for about 40 years, actually now 41 years. They came about 1970, just at the time when there was a lot of environmental legislation being developed in the United States. Environmental Protection Agency was being created. It was the time when we had the first Earth Day. So a lot of concerns, a lot of different political movements going on in the country in the late 60s, early 70s. So they were caught up in all that was going on in those activities. To this day, yes, they are skeptical about nuclear power, but some of their leading analysts, Tom Cochran, who's a dear colleague of mine, and Professor Settles. Tom Cochran grew up in Tennessee, maybe not too far from where Dr. Settle grew up. He has a more nuanced view of nuclear power. He said, if you can put a price of carbon emissions, then it could favor nuclear power, and it could favor solar and wind and those other kind of renewable technologies. So he's their leading nuclear power analyst on staff. So, and that's an indication of pretty much where NRDC is in terms of their staff view. Greenpeace, still very much anti-nuclear, but one of their founders, Patrick Moore, he's a renegade, or they used to call him a traitor, Greenpeace. And so Mr. Moore is very pro-nuclear, although he's skeptical about human-induced climate change. It's very interesting. I've heard him give a talk, and yeah, he's part of nuclear power for other reasons. And the Sierra Club, and here's a quote right from their website, and it's interesting, their website, they go back the last 40-some years, and they show the resolution they have on their board, and they said they still remain unequivocally opposed to nuclear power. Just to show you a slightly different view, or actually a completely different view, World Resources Institute, Jonathan Lash, who is their former president, he just recently left and became president of Hampshire College. He's called nuclear power a necessary evil. This interview he did with Rolling Stone magazine. And then a couple of other notable environmentalists and scientists who are supportive of nuclear power. Stuart Brand, he goes back to the time, the hippie era in late 1960s, 70s. He created the Whole Earth catalog. He's given a talk. You can go to TED Talks and you can listen to him speak very enthusiastically about nuclear power. And then James Lovelock, who's a British scientist, he created what's called the Gaia hypothesis, that Earth's this self-healing type of system. So he's worried that the self-healing system is broken down now because of what people have done to the planet. And he believes that nuclear power has to play a huge role in addressing climate change problem. Well, I told you I'd mention a little bit about NEPA, and I won't really say much more than this. And John Adams, not the President John Adams, but John H. Adams, the founder of NRDC, and his memoirs just came out this year. He said that this was, quote, the cornerstone of the slew of environmental laws that would follow. And he goes on in the book about how NRDC really paved the ground in terms of implementing NEPA. And he also said that this required every new federal action that significantly affected the environment had to be the subject of a detailed impact assessment. So there's these EISs, environmental impact statements, that have to be written for every single major federal action, like building a nuclear power plant. Just to mention a few other important third-party activities in this transitional period of 1970s. The American Physical Society, which is the leading body that represents physicists in the United States, they did an independent study of nuclear safety and used probability risk assessments to look at the various pathways for accidents. There was a Ford MITRE study, not President Ford, but Ford Foundation and MITRE study that came out in 1976. There's an all-star cast of analysts who wrote that report. I happen to have one of the original copies, and I had the lead drafter report actually signed it a few years ago, so now it's actually worth some money. This was briefed to President Ford, and they convinced him to put a halt to reprocessing of spent nuclear fuel that was designed to recycle plutonium. Their arguments were twofold. One, it wasn't economically competitive, and then two, it's a proliferation threat. Not in the United States, but in other countries. If they adopted what the United States was doing, it could lead to further proliferation because of the use of plutonium. So Ford put a temporary halt to it, and in early '77, when President Carter came into office, they briefed him as well, and he took further steps to halt reprocessing. That got reversed again when President Reagan came in, but by the time he came in, it was like 4 years later, that there are independent studies arguing against the breeder reactor program at Clinch River, and also a lot of independent experts are already weighing in terms of developing the Nuclear Non-Proliferation Act of 1978 that further discouraged the spread of reprocessing technologies around the world. And also mentioned that INPO was developed in '79. So a lot of work was done in the '70s. Now, in my remaining time, I'm going to talk about just 3 examples of some more recent activity, contemporary activity that third parties are involved in. I'll talk about an independent scientific analysis of nuclear energy's role in climate change, and actually, well, it's work I've done with Dr. Settle and one of my assistants. And I'll look at work done by Robert Alvarez and his team of researchers assessing the vulnerability of spent fuel pools to terrorist attacks and accidents, and then look at concerns about the NRC's licensing of a laser enrichment facility in Wilmington, North Carolina. Okay, so I mentioned earlier that nuclear power plays a role in countering climate change because an operating nuclear power plant, it's not burning fossil fuels, it's not emitting CO2, it's not emitting other greenhouse gases. So if you can have nuclear power plants displace or replace coal plants or natural gas plants, anything using fossil fuels, that's a good thing for the environment in terms of reducing the amount of greenhouse gases going into the atmosphere. Well, how much a role can nuclear play is the question that I'm going to ask, and I'll walk you through a calculation very briefly. So first, it's important to realize that one technology by itself can't do it all. In 2004, 2 scientists from Princeton University, Stephen Pacala and Robert Sokolow, they published a groundbreaking article in Science magazine, and they identified 15 technologies that could be deployed that would reduce greenhouse gas emissions. So they started in 2004 and they went out to mid-century, and they projected business as usual emissions in the atmosphere. And they said that business as usual projections are that will go from about 7 to 8 billion tons of carbon being emitted in the atmosphere around 2004 to 15 or 16 or more, maybe 18 billion tons of carbon being emitted in the atmosphere by mid-century. So what they said is you can divide and conquer. You can split up this emission triangle and say that and define various what are called wedges. So each wedge is a technology that, if it's deployed, will result in less greenhouse gases being emitted into the atmosphere. So, for example, you have more energy efficient cars. If you can take the miles per gallon of the average car from 30 miles per gallon to 60 miles per gallon, you can do that for 1 billion cars. That's one wedge. So that shows you the scale we're talking about. For nuclear, if you can build an additional 700 large reactors, what I mean by large is 1,000 megawatt electric power reactors, so 700 billion watts of electrical power has to come online in the next 40-some years, and you've got to replace all the existing reactors because most of those will have to be retired in the next 40-some years. So you're going to have to build over 1,000 megawatt electric reactors over the next 40-some years. So keep that in mind. So if you can do math quickly in your head, so how quickly do you have to connect one of these reactors to the electrical grid? Any guesses? It's 2 weeks. So every 14 days or a fortnight, it doesn't matter if it's 6 one way, half dozen the other, or 14 days or 2 weeks to do it. But this shows you how quickly you got to connect a nuclear reactor to the grid under that scenario where you just have one wedge filled. So that's only about 7 or 8, a seventh or an eighth of what we need to do to flatten that emissions curve.
That's 30 minutes.
Thank you. Let me stop talking more about climate change and shift to a different topic that's still a concern. This relates to the Fukushima Daiichi accident. In reactor unit number 4, there was a hydrogen explosion, and in the first week, there were serious concerns that the water in the pool had completely drained. The chairman of the NRC, Dr. Greg Yasko, testified to Congress, and he said based on the information he had, it looked like there was really no water in the pool, or very little water in the pool. TEPCO, Tokyo Electric Power, eventually said, no, there's still water in the pool. Finally, they realized, yes, there was still water there, but there were serious concerns that this pool gets drained, and this is showing a pool with nuclear spent fuel assemblies are stored there. Here's one in the United States. Japan, they have similar type of pools. And in the U.S., these are becoming overcrowded. In the Japanese nuclear plant, it wasn't overcrowded, but there was enough spent fuel in the pool that if it drained, that it could catch fire. And if it catches fire, then it could release radioactive materials. 10 years before, right after 9/11, Dr. Alvarez and his group of independent experts, they looked at the potential that terrorists could attack such pools and drain the water and lead to dispersal radioactivity. This prompted the National Academy of Sciences to do a report, both classified and unclassified versions, and the Nuclear Regulatory Commission did their own assessment as well. So this is an example of a third party influencing 2 government agencies to do a review. I won't have time to go over this in any detail, so I'm going to push on. So the solution that Dr. Alvarez and his group recommended is to transfer the spent fuel material in the overcrowded pools in these dry storage casks, which are very safe and secure and probably could last for at least 100 years. This is being done in Germany, and they estimated that for the U.S., all the spent fuel we have, it costs anywhere from $3 to $5 billion to transfer in these casks. The industry said, well, we're worried, one, about the cost, we're also worried about radiation safety. that if you're transferring material in these dry storage casks, you might expose workers to excess radiation. So it's not that clear-cut whether this should be done or not. And this came up yet again in the Blue Ribbon Commission that just finalizing its work. Blue Ribbon Commission was established by President Obama and Secretary of Energy Steve Chu to take a new look at the political and technical issues involved in disposing of radioactive waste. Okay, remaining minute or so I have left here, I'm just going to draw your attention to another contemporary issue where third-party groups are involved in. There's laser enrichment going on. Sorry, I can't help it. I say laser, and like Dr. Evil, I have to leave air quotes. But in Wilmington, there's a company called Global Laser Enrichment, and it's a consortium of at least three major companies: General Electric, Nuclear; Hitachi, which Hitachi now basically owns GE Nuclear; and Cameco, which is the Canadian uranium mining company. So this is a technology that originally developed in Australia by Dr. Michael Goldsworthy back in the 1990s. And then the Australian government transferred the technology to the U.S. under an agreement to keep it secret. So it's a classified technology. But the real question is, with thousands of workers working at this plant and with the efforts to commercialize the technology, will the secret remain secret? Think back to the Manhattan Project, the very beginning of my talk. The real secret of the bomb was, once we knew it worked, then any country that was determined enough to put the resources toward it could figure out how to make atomic bombs. The American Physical Society has recently petitioned the NRC to do a more thorough proliferation assessment before a final license is issued, and my organization, FAS, has sent a letter of support to that petition. Okay, next to last slide, and then I'll stop. Just a few observations about U.S. and Japan. So one of the main points I want to get across to you, and you think you already know this, having lived in the United States, grown up in the U.S., we have a very vibrant civil society in this country. And that goes back to the founding of the United States. A lot of other countries don't have that. I think we take it for granted. When I've been to Japan, I've been to other countries, they said, wow, gee, we wish we had your kind of civil society, the non-governmental organizations, even the lobbyists, that play an active role. Sometimes it's good, sometimes it's bad, but I would argue in balance for nuclear power, it's arguably positive. Maybe Professor Carr might have a slightly different view. We'll hear in a moment. But Japan, in contrast, has a very limited civil society. When I was there in Tokyo in late July, I was having some meetings trying to have a dialogue with various experts at universities, see if they could stimulate growth of their own type of civil society. Because they really do need the independent experts to foster the public debate and to provide a set of experts to make sure that they can establish a truly strong and independent regulatory agency. So with that, I'll thank you for your attention and do a shameless plug of my recent book, Nuclear Energy, What Everyone Needs to Know, which was a collaboration with Washington Lee University. This book came out just a few weeks after Fukushima, so there is some Fukushima material in the book, and it's designed to teach the general public about this topic. Thank you.
Thank you, Dr. Burke. Professor Carr.
Are you going to need this to take the time to use this? Yep. Now that the technical part's out of the way, let me just tell you where I stand on my familiarity with computer technology. When I became affiliated with the firm of Wayne Morris, I went up to the Washington office and spent 2.5 days being treated or trained on the Dwayne Morris computer system and Centrix. At the end of the 2.5 days, I came out of the room and I told the secretary of the managing partner of the energy practice that I now know what a dog watching TV feels like. I'm going to talk about the U.S. regulatory process for nuclear power. As I say there, you can see, I characterize it as regulation from art form. In doing this, what I'm going to do is place nuclear power in its U.S. regulatory context and its operational utility context, talk briefly about the development of the domestic nuclear industry. Dr. Ferguson gave some background on that. Problems encountered under the initially developed licensing process, changes to the present process. I'll say a little bit about Fukushima, and then finally, as a wrap-up, I'll go into how the NRC conducts its business with its various constituencies. Let me start by saying that the United States electric utility industry in general is the most heavily regulated industry in the world. And when you add to that, I'm talking now about on the state level, the federal level, in two aspects. When you add to the state and federal regulation of the nuclear power industry, the regulation associated with a nuclear ownership and operation of a nuclear plant, you indeed, as I said, if you didn't have it before, you have the most heavily regulated industry in the world. Here's what state regulatory agencies cover with respect to regulation of the electric business. You can see there the multitude of areas that they deal with. And just as an illustration, here are the state of Virginia's statutes and regulations with respect to regulation of the electric utilities within the state of Virginia. Look at this. Structure, generation, additions, expansions, mix, rate regulation, transmission line, permitting, and siting. The list goes on. Now, the state regulator and this regulator, the FERC, the Federal Energy Regulatory Commission, are economic regulators. Here's what the FERC regulates. That whole list there, you will notice that some of them combine or are the same areas as are regulated by the states. There's the Federal Power Act, and there are the regulations that the FERC uses. Now, I know this is going to be unfamiliar to a lot of you students because you don't look at books, you look at computer screens. But there's the totality of it. Now, the Nuclear Regulatory Commission, the NRC, is not an economic regulator. If you don't take anything else away today, write that down twice. It is not an economic regulator. But the NRC actions have huge consequences for economic regulators. And while I'm at it, there's the Atomic Energy Act and other legislation. And there are the regulations. And if you want to get a feel for this, these books are not written in extra large print. I'm just going to pass one around. And to take that, and let people just flip through that. And that's one volume. So, though it's not an economic regulator, its actions, as I said, had significant consequences for the economic regulators. The NRC may do a cost-benefit analysis before it imposes a regulation. But once it makes that decision, it does not care what it costs the utility to implement it. And that has significant consequences for the economic regulators. I'm going to talk a bit more about that as we move forward. But let's look at today, where we are today. Here's a chart that gives you an idea of the sources of generation of electricity in the United States. You can see that coal is about 45%. Natural gas is roughly 24% as it stands now, but is increasing. Nuclear is around 20%. Then we have the rest made up of hydroelectric, renewables, and other stuff. Nuclear plants and coal plants are primarily baseload facilities. What that means is they run at 100% capacity, 24 hours a day, 7 days a week, unless they're taken out of service for routine maintenance for a nuclear plant refueling, or unless they break down. So when you combine that with the requirements that the electric utilities have to maintain adequate service on their systems, you really have, for nuclear and coal, you have generating facilities that cannot be substituted for with renewables like wind and solar. I don't care what people tell you. You hear people babble about smart grid and storage and that kind of stuff. Take it to the bank. There is no substitute for baseload generation for nuclear and coal. Where are we now? For nuclear, 104 operating units, about 20%. As the previous chart showed, these nuclear plants are running now at better than a 90% capacity factor. That means they generate 100% of their rated capacity 90% of the time. And a good bit of that time, that 10% comes from routine maintenance, some of it from unplanned outages. The chart there shows you that the refueling outages are very quick, 16 to 45 days. There's record output, and in certain areas of the country, the power costs from nuclear are about 25 to 30% of the remaining power costs. Now, we are utilizing these plants in a number of different ways. We are extending the life of their operating licenses. They were initially licensed for a 40-year period. That 40-year period had nothing to do with safety issues. Nothing at all to do with safety issues. We now have about 60 reactors that have already been granted 20-year extensions. We have a number of others in the pipeline, some of which are being contested. And when we finish, we're going to have 98 out of 104 reactors relicensed for an additional 20 years of operations. Dr. Ferguson said, after those 20 years, we're going to have to start taking them out of service. Now, there's also something known as power uprates. Basically what that is, when plants were initially licensed, they were licensed at a certain megawatt thermal level. Not electric, but thermal. Thermal is the heat they produce, which in turn produces electricity. Some of these plants have been through an upgrade cycle more than once. When we finish with this in about the next 5 years, we essentially, through upgrades, will have added another 9,270 megawatts, almost 9,300 megawatts of generating capacity to the system from the current plants. That's like building another 8 new nuclear units. How did this happen? Dr. Ferguson gave you a good overview. The swords into plowshares quote is most appropriate. Frankly, when one looks at the early days of transition from the nuclear program, there were all sorts of, the weapons program, all sorts of things were considered, including putting nuclear reactors in airplanes to use to power the engines. And they actually got one that worked. The problem was the reactor was so heavy you couldn't put anything else in there. It was sort of limited its use as passenger aircraft or as a bomb. There was a tremendous debate over separating the weapons program and giving any nuclear expertise, information to civilians, as Dr. Ferguson said. However, we did have the Atomic Energy Act passed in 1954. Now, before we start talking about what happened in the past, let's talk for a moment about how the NRC conducts its business. And Dr. Ferguson mentioned some of this. First, it is open and transparent. There are 3 ways. There are notice and comment rulemakings. Those are publicly done. Anyone can participate in that process simply by filing comments. This process is consistent with the Administrative Procedure Act. Then there are public hearings. These are adjudicatory trial type proceedings conducted under the Administrative Procedure Act. And let me just tell you, you can talk to people who do civil litigation. I think that this is much more difficult, much more complex than 99% of the civil cases filed. Here's why. In the first place, when you're dealing with an administrative agency, be it the NRC, the FERC, the SEC, the FTC, you are dealing with people who are experts in the area. You're not dealing with some judge who's today listening to whether somebody ran a stop sign and T-boned somebody else. You're not dealing with a jury or a witness that may or may not have seen the accident. You're not dealing with a judge who, in addition to the stop sign, is dealing with a contract issue or a bond issue or a financial issue. You are dealing with people who from top to bottom are experts in the subject matter that you're dealing with. And also, when you litigate before the NRC, unlike FERC and the others, which have a single administrative law judge, in the NRC, you are litigating before a 3-member licensing panel. You'll have a lawyer in charge, and the lawyer, hopefully, knows what he or she is doing. But you also have a nuclear scientist and an environmentalist on that panel. Everything is done in writing. You don't put somebody on the stand and ask them questions and make an impression on a jury. All testimony and exhibits are pre-filed in writing. You don't blow smoke in somebody's face and sit down. So it is a challenge, an interesting challenge, but a very real challenge. And these proceedings, again, are open and transparent. I will say this. If you're one of the organizations that Charles talked about, the public interest type organizations, it is difficult for you to get into these proceedings, the trial type proceedings, the licensing proceedings, because the NRC doesn't want somebody in there that doesn't know what they're talking about. And you have to show, before you can get in, you have to show that you have a contribution that you can make to that process. So you've got that trial type hearing. You also have another type of hearing, which is they call a legislative type hearing, or abbreviated. For the life of me, I can't imagine why anybody would select it. You give up rights of cross-examination. Just to give you one example of what you can learn on cross-examination in a licensing case that I handled for Duke Power, we had a serious issue with respect to potential hydrogen explosion in a containment in the event of an accident. The kind of thing that happened in Fukushima. This was a number of years ago, and the interveners had put on a witness, a delightful gentleman, who was a chemistry PhD, well accomplished, but his structural expertise was shown on cross-examination to come from two areas. One was he dealt with wash and wear fabrics, so he knew about structures from the crimping in wash and wear fabrics when they put permanent seams in. The other was that he had built model airplanes in his youth. That's what cross-examination can do for you. And I would never, ever give up that right if I had the choice. Okay, then we have a commission also that can issue orders to licensees, assuming that they properly frame the orders within the context of the regulations. So that's how the business is conducted. Dr. Ferguson mentioned that early on we had potential conflicts of interest in the way that the AEC, the Atomic Energy Commission, was set up, because it was the promoter, researcher, developer, and regulator over nuclear power. Now, the AEC did what it could to allay those sorts of concerns, set up a completely different section and a different building known as the regulatory section. This was down in Bethesda. The rest of the agency was out in Germantown. You're familiar with the Washington area. Something. And those were the days before fax and computers and all that sort of stuff. You either went there in person or you talked on the telephone. As an employee of the regulatory part, I never was particularly aware of influence from the Germantown side, although I'm sure at the higher levels it existed. So that was an issue. But the big issue here was the two-step licensing process adopted by the AEC in its early days. And remember, this was the day when you were developing the industry. It was not mature, and the regulator was not mature. But what you had was an application for a construction permit that considered the concept of the reactor design, environmental issues, and site suitability, geology, hydrology, seismology. That carried with it a mandatory public hearing. Even if you didn't have interveners, you had to have a public hearing. Once the construction permit was issued, then the plant was designed and built. Hundreds of millions of dollars were invested. And when construction was almost complete, you got to file an application for an operating license. Now, you all are generally aspiring young lawyers. Put yourself in the position of standing before your clients, Electric Utility Board of Directors, and explaining to them that this nuclear plant that they've been working on for 8 years and that they've sunk over $1 billion into, now we're going to file an application for a license to see if we get to operate it. You're going to have bad days in the practice of law, and this is going to rank right up there with them. Okay? So, an opportunity for public hearing was offered there. And assuming you got through it, and that was not the case with the number of plants under construction, you got to operate the plant. Was that process ill-suited to the task? Well, let's spend a minute to talk about what was going on. First, as I said, this was not a mature industry. The design at the time of the start of construction may only be 15 or 20% complete. Project management of this enormous undertaking was sometimes lacking. You would have, at the height of construction of one of these plants, you would have 7,000 or 8,000 people on the site. You would have endless numbers of contractors and subcontractors. If the nuclear regulatory process is nothing else, it's a process about documentation. And the documentation wasn't always up to snuff. That's one issue. Dr. Ferguson alluded to problems before TMI, and that was one of them. Then, you didn't have a good business environment back in the 1970s. Inflation was out of control. You had the Arab oil embargo, where prices of electricity went way up and the design decreased. Because of the economic regulator, you were not able to recover your cost until such time as the facility was needed. So the construction period was stretched out right at its most vulnerable time from an interest rate standpoint, because the money's necessary to borrow the plant. The prime rate was 15, 16, 17%. So you had huge cost overruns. You had the 3 Mile Island accident, and again, with a not mature industry or regulator, the response to that accident from a regulatory and business and construction standpoint was in many respects chaotic. One group would come in, from the NRC, would come in and tell you to tear out what you had already designed and constructed and put something else in. You get that half finished, another group would come in and tell you to tear that out and do it over again. So you had all of those, which caused major economic regulatory issues. Then you had, we just didn't run the plants very well. We didn't know what to do. We had a bunch of shutdowns. We had lots of low capacity factors, and we had very lengthy refueling outages. So the NRC regulates everything with respect to construction. Site selection, approval, plant design, construction, operation. Daily monitors all operation. How does it do this? Its staff, and its staff is very well qualified, highly educated, very technically savvy. They have resident inspectors, 2 or 3 at each plant site, that are on site daily. They stay on site, they walk around, they look at things, they report back to headquarters. You've got inspection teams that will come in. You have an enforcement arm, you actually have a criminal investigation arm. They have meetings, discussions with the applicants or licensees, all of it transparent. The public is invited to all these meetings. Okay, as we said earlier, and as Dr. Ferguson said, we had the issue with respect to whether there was an independent nuclear regulator. The Congress solved that in 1974 when it established the NRC as a separate and independent regulatory agency. This brings us up to where we are today pre-Fukushima. No major incidents since TMI and Chernobyl. Much improved capacity factor, new political climate. Dr. Ferguson talked a little bit about that. Simplified regulatory process that I'll go into in a moment, and pre-approved design. Now, rather than that 2-step process, we now have one that's 3 steps, but with a significant difference. You can get pre-approval of the site, you can get pre-approval of the reactor design, and then you marry that to the site and you file a combined application for construction and operation. All of this is done before the hugely significant capital investment is made. And right now the current estimate is for these new nuclear plants coming is a 2-unit plant is in the neighborhood of $16 to $18 billion. Huge amount of money. Here's a diagram. Early site permit. public hearing opportunity. Design certification, public comment opportunity, because that's a notice and comment process. Combined license, opportunity for public hearing. Then we construct it. Then the NRC does a final check. It's been doing this all along. Have the acceptance criteria been met? An opportunity for public hearing. And then the plant operates. Now, I argue that that is a much more effective process from a public hearing standpoint than the old one. In the old one, the public could participate either before they knew what was going, anybody knew what was happening, really, or after it was too late to have any effective input. This is different. Here's where we are today. A number of COLs have been filed. A number of applications for early site review have been filed, been approved. Advanced reactor design certifications have been filed. Some have been reviewed or approved. Some are still under review. And we have 2 COL applications in the final stages, and the COL should be issued probably by the end of this year. One of them is 2 units at the existing Vogel plant in East Georgia. Georgia Power is the primary applicant and licensee, although it has co-owners. And one of them is the Virgil Summer plant, South Carolina electric and gas plant north of Columbia. 2 units there at $16 to $18 billion per pop. Fukushima, very quickly, Dr. Ferguson talked about this. We had a massive earthquake, and the earthquake resulted, 1, in the loss of off-site power, and 2, substantial damage to the infrastructure in the area of the plant. But the plant reacted exactly as it should have, and shut down, the reactors shut down, and the diesel generators kicked in. Unfortunately, within an hour, a tsunami hit that was 10 feet higher than the wall designed to protect against tsunamis, and wiped out all the on-site power. Because these things need, you talk about shutting down a reactor, and Dr. Settle and Dr. Ferguson will probably cringe when I say this, the English major talking about technical issues. But when you scram the reactor and shove the control rods in, it stops the chain reaction. You've got huge amounts of decay heat that have to be removed. It takes a week or more to bring it to cold shutdown with constant circulation of cooling water, and for that you need electricity. In Fukushima, you had batteries, but they were only good for, 18 hours or something like that. And after that, the cooling water started boiling away. Because remember, the infrastructure around the plant had been destroyed. Couldn't get in by highway, all the electrical system had been wiped out, so they couldn't restore power to the plant. So bad things started happening. I'll just skip through that. Temporary cooling, they tried to bring in cooling. They finally got hooked up where they could pump seawater into the reactors, which even if they hadn't been severely damaged, rules them out for any further use, as I understand it.
That's 30 minutes.
30 minutes, okay. Let me just say very quickly, the NRC, this shows the difference between today's world and what we had after TMI. The NRC immediately sent a response team over. The response team reported back as best they knew. The NRC also initiated task force reports. The task force made its report in August, reported to the commission. The commission then, rather than adopting the task force report, which would have happened probably after TMI, told the staff, take this report and give it a peer review and also consult with stakeholders. The staff did that, came back to the commission. The commission said, we accept your recommendations. The staff then prioritized the recommendations. That's pending before the commission. Here's why this is significant. This is now a commission document. It's not, no matter how well, it's not various groups of the staff running around. And it's a document which, again, has had input from the third parties that Charles talked about. And I think this will come out pretty well. It certainly is a vast, vast difference from what we saw before. Now, here's how the NRC interacts with interested constituents. Here's who they are. As I said, they're highly technically qualified and very skilled. They deal with the Congress on a daily basis. The Congress is not at all hesitant about exercising its oversight responsibilities through its relevant committees. And they do a pretty good job of it. Yes, there's posturing, there always is when you deal with politicians, but by and large, they exercise their oversight responsibility in a good way. The industry. The NRC regulates the industry. Don't believe this stuff you hear about the cozy relationship. Yes, the technical people talk to each other because that's the best way to solve technical problems. And there is communication. INPO, the World Association of Nuclear Operators, the individual licensees. But I'm going to tell you something. If you're in the industry, it's a good relationship, but many times it's something like having a big brother. And the big brother can help you along and you can deal with the big brother, but every once in a while he turns around and whales the living hell out of it. That happens. That happens. Those relationships are transparent. Public meetings are noticed, the public is invited. As I said, it can occur in both construction and operation. We've talked about the public hearings. How do they interact with the public? Again, as I said, they participate in the matter several different levels. Meetings, rulemakings, they can file petitions for action, they can file comments, we have the public hearings. As I said, they're very open, but I'm not gonna try to sugarcoat it. You don't get into an NRC public hearing as a party unless you have something substantive to contribute, which is not always the case. And then finally, the NRC deals with the media in its own way, which is, we all do the best we can deal with the media. So, thank you all very much for your attention. Tom, thank you for timekeeping. And one of the more entertaining people I've met in the last 20 years or so, Professor Goodman, is now going to talk to you about the Japanese. We actually have somebody here finally who knows what he's talking about.
While the technology is being handled, I'd like you to do some technology. If you wouldn't mind just taking your head, going like this, and going like that on each side. Because I don't want you to be confused by anything you've already heard. Because what you're going to hear is going to be very different. I'm going to talk about the process in Japan. You will hear something about civil society, picking up on Dr. Ferguson's comments, but you will not hear, I'm sorry, Professor Carr, you will not hear about rulemaking because it doesn't play any role in what we're talking about. You will not hear about public hearings which are in the nature of adjudications because they do not play any role in what we're going to be talking about. And you will not hear anything about orders except for licensing orders because in Japan they don't regulate by orders. They regulate by guidance. So you'll hear about guidance. Let me start. Let me start with the fact that licensing takes place under METI, which is one of the most powerful ministries in Japan. They have a group in METI called NISA, which is the Nuclear Industry Safety Agency. You should not be confused by its title to believe that it is a nuclear industry safety agency. Nuclear is a part of what this agency does. It is also responsible for such things as explosives, high pressure gas, petroleum industrial complexes, mines, and certain other aspects. Now, if you want to put up a nuclear plant, you have to make a license application to NISA. NISA has a very formal list of what kind of information they want you to provide them. In the license application, you provide that to NISA. NISA then reviews your data. They consult with the Nuclear Safety Agency, Nuclear Safety Commission in Japan. And amongst other things, the NISA website tells us that they're supposed to consider geological conditions, hydraulics, which includes tsunami and flooding, and earthquakes. Japan is, of course, a very active earthquake zone country. If you've ever spent any time in Japan, you've been subjected to earthquakes. It doesn't matter really where in Japan you've been. If you've never been in an earthquake, it can be kind of interesting. The first earthquake I was in Japan, I was on the 32nd floor of a big building in Shinjuku in Tokyo with my wife, waiting for some people to come in, and all of a sudden the building went like that. I'd been in an earthquake, and a voice shortly thereafter came over the loudspeaker system in Japanese. I had absolutely no idea what was being said. And finally the door opened. The head of the legal department of the company came in and she said, we can now use the elevators. And life went on as it normally goes on in Japan, and I've learned to live with that on my various trips. Now, the parties to the initial licensing, well, the licensing process are the power company and NISA. Dr. Carr indicated it might be difficult in the United States for certain third parties to get in. In Japan, it's not difficult. The parties to the process are the power company and NISA. They have public hearings, but don't be confused. They're not the public hearings Professor Carr was talking about. They're not adjudicatory hearings. They're not hearings with witnesses or cross-examination. They're hearings that started in the early days of nuclear energy in Japan. You know, Japan's not happy about nuclear things. They have a long memory, and they remember Hiroshima, and they remember Nagasaki, and they're worried about nuclear. The everyday person in the street is worried about nuclear. And as a consequence, when the government decided that nuclear power was important for Japan, they met some resistance. And so they had public hearings, which were basically in the nature of public education sessions in which the government educated the public to what the government wanted to educate the public about, which was the safety and the security provided by nuclear power. Unlike the United States, Japan does not have a single oil well. if you want a gallon of oil, you want a gallon of gasoline, it's got to be imported. And we don't have in Japan all these vast reserves of natural gas. If you want natural gas, you import it. Now, there's the possibility that there will be some natural gas that will be domestically produced once Japan and China work out their problems about that natural gas pool out in, I think it's the South China Sea, which, by the way, China is tapping into and Japan has not yet started to tap into. So Japan also, it has hydropower, but if you've ever been to Japan, you will know that it doesn't have rivers like we have rivers. Remember, this is an island nation. We are a continental nation. So it has short, powerful rivers with big drops in the rainy season and not so much in the dry season. And with the Arab oil embargo some years ago, Japan found itself in very serious trouble about producing energy, and nuclear was an answer in Japan. So nuclear power was very important to the government in terms of bringing it to the people. And if you look at where nuclear power plants are scattered around Japan, you'll see that they tend to be scattered in areas which were uneconomically developed areas. You know, this Fukushima, for example, it's not located in Fukushima, which is a city. It's located in Tohoku, which is northeast, east, northeastern Japan. Right? And it's located along the coast where you would expect to have and do have fishing villages, which is usually not terribly high-paying work. And so there are some economic advantages of putting the plants there. And that was discussed in these early public meetings, and you still have these kinds of public meetings when it comes to to siting plants. Now, if the licensee is the company that requests a license is denied a license, it of course can seek judicial review. The statute doesn't provide for judicial review by the public, but there is a law in Japan called the Administrative Case Litigation Law. Again, unlike the United States, where you want to bring a lawsuit, you go down and bring a lawsuit under the, civil procedure code of whatever state you're in, or, the federal statute is 28 U.S.C., right? In Japan, they have a special law for administrative litigation, the Administrative Case Litigation Law, and you can bring an action under the Administrative Case Litigation Law as a practical matter prior to Fukushima, and we don't know what will happen in the future. Bringing such a litigation might in fact slow down the process a little bit, but it was very unlikely to stop the process. We'll come back to litigation in a little bit. Japan is a unitary state, unlike the United States, which has semi-sovereign states in its federation, and the prefectures in Japan are not states. They don't have the same kind of authority as states. But if you are going to disturb the terrain in a significant way, then you have to apply to the prefecture. And of course, a nuclear power plant, you want to put it where there's a lot of water. In the United States, we can put it by big lakes, and there are some plants in Japan that are near Lake Biwa, I guess. There are some plants there, but mostly the plants in Japan are along the ocean, along the ocean front, which is where the water comes from, and that means you have to do certain work on the land. In Fukushima, for example, there was a high cliff, and it's difficult to get the water up from the ocean to the top of the cliff, so what they did is they pulled down the cliff. And you can see what happened when the tsunami came in. Had it stayed up at the top of the cliff, there might have been a very different result. But to take down that cliff, for example, you have to go to the prefecture and get the prefecture authority. Unlike the United States, I don't know if you've taken Prince versus United States in any of your courses, or what is it, New York against U.S., where the Supreme Court has said that when the federal government has authority to do things, it could create its own agencies to do it, but it can't make the state an agency of the national government. In Prince, it couldn't make the deputy sheriffs or the sheriffs agents of the national government to do the necessary steps before somebody could be sold a gun. If you wanted to do it, create your own officials and do it. That's not the case in Japan because it's a unitary government, and in fact the national government can make the prefectures, and has made the prefectures in many regards, agencies of the national government, and can even order the governor of the prefecture to do various things. So that while the prefecture has authority, it may not have final authority in this way. Prior to Fukushima, there were some cases in which prefectures rejected hosting power plants, but basically there wasn't much problem getting the prefectures and the local authorities to approve because of all the bennies that the government would give the local authority if it did approve. Once the license is approved and we're ready to go, then an agreement is signed between the prefecture as the hosting community and the utility, and this is a safety agreement, and that becomes interesting as a legal matter because there is the question as to what the effect of such hosting agreements are. Plants in Japan go offline every 13 months for safety inspections. And before they can come back online under these hosting agreements, they have to get the permission of the prefecture to come back online. Now, some prefectures have indicated they've got some concerns since Fukushima about bringing these things back online. That creates some interesting issues which we will talk about. Prior to Fukushima, there really were no problems. I don't know if you've been following the news about the difficulties the United States and Japan have been having about the Futma Air Base on Okinawa. Agreements were signed years ago about moving the base away from the big city in Okinawa and putting it closer to the coast, kind of like where you'd put a nuclear power plant, closer to the coast, and somehow it hasn't gotten moved yet, and you remember the Hatoyama government fell because it said it wasn't going to move it as they had agreed with the United States, and all sorts of problems arose. There have been 2 cases in Japan in which the national government has directed a prefectural governor to do something, where the prefectural government objected to doing it. The Supreme Court of Japan has held that the national government can order them to do it because it's a unitary state. Both cases involve U.S. military bases. You can see how long it's taken for Futma. What if a prefecture refuses in the future acting on the basis of its hosting agreement. Are we going to be in a years and years long process? And will the plant be operating during that time? Will it come back online? We don't know the answers to these questions. I suspect the plant will be online and operating, but we don't know. Fundamental differences in the administrative law process in Japan and the United States, well, there's no notice in common rulemaking, so Professor Carr, we have to wash that out if we're dealing with Japan. There's virtually no formal adjudication. There certainly is none in the nuclear area. There is some formal adjudication. They have a couple of alphabet agencies like the FTC, which is similar to our FTC, even has the same initials. It does have similar authority. It does have some adjudicatory procedures and so on. Under the administrative case litigation law, a party or entity whose legal right has been adversely affected can sue to protect that legal right. Legal right is a term of art in the administrative case litigation law. It's not sufficient that you suffer injury in fact. If you suffer the same as the public in general, that's called a reflex of the government action and doesn't give right to a violation of a legal right. If you take my land, that is, you've taken a legal right because I had the land. If there's a statute which gives me a legal right, such as the Forestry Act gives certain landowners further down the stream certain rights, then you've taken a legal right. It's not the U.S. zone of interests analysis. It's a much stricter standard, which brings us to the Manju 1 and Manju 2 reactor cases. Manju is, of course, a fast breeder reactor. Professor Charles, I think you talked about the report which said we're not doing fast breeders here in the United States.
I've been to Manju, actually. I was there 4 years ago, yeah.
Yeah. It was probably closed.
It was, yes.
It was.
They were doing some testing at the time, but it was closed, yeah.
Yeah. They've had a lot of problems with Manju, and that brought up two pieces of litigation. In the first litigation, the question was whether people living within 60 kilometers of Manju had standing to sue. The statute dealing with this issue had provided people within, I think, 10 or 20 kilometers could object and could sue, actually, under administrative case litigation law. People within 60 sought to sue, and the court opened up standing to people within the 60-kilometer range. That's interesting for those who are interested in Japanese administrative law because some recent changes have been made in the administrative case litigation law which seek to mirror the reasoning of the court in the Manju 1 case. What happened, of course, was now they had standing, so then the question was, could they win the lawsuit? And, of course, in the Manju 2 case, as would have been predictable, they lost, the court holding that the government's decision that the plant was safe was not, quote, unreasonable. Not that it was reasonable, but that it was not, quote, unreasonable, which tells us something about the standard of review in administrative cases in Japan. There is enormous deference given to the government's decision. You may not know this, but judges in Japan are a bureaucracy. They're not appointed like here in the United States. They don't run for election as you have in some states. They're not appointed by the governor as you have in some states. They're not like federal judges who are appointed by the president with the advice and consent of the Senate and serve for a lifetime. They are people who come out of the law school, pass the bar exam, go to a one-year training course run by the Secretariat, decide at that point if they want to be a judge, If they're smart enough and good enough, the Secretariat appoints them to be a judge. Now you're a judge, first 10 years of training, and after that you get 10-year renewals of your judgeship. So it's a bureaucracy, and in one sense you're asking a judicial bureaucrat to overturn the decision of an administrative bureaucrat who presumably has more information and better information than the judge has. So you're going to have a great deal of difficulty getting that overturned. And while all this is going on, you might want to seek an injunction to prevent the plant from being built. The odds are you are not going to get it, because you have to proceed for an injunction under the administrative case litigation law, which has a very, very high standard for getting an injunction. In some of the environmental cases, lawyers argued that the standard should be the same standard as in an ordinary civil suit. That was rejected by the court. Of course, Japan is a civil law system, so there's no inherent equity authority as we have in the United States. So any injunction you want to get has to be provided for in a law, and the administrative case litigation law makes it difficult. One of the problems is that Professor Carr was talking about the two-stage. You invested all this money in the first stage. Now you've got to apply for another license. Well, you've invested all this money building the plant while the lawsuit is continuing in Japan. You haven't gotten an injunction. The administrative case litigation law has a provision which calls for what's called a circumstance decision, which says if the government acted wrongfully in its administrative decision, we still don't tear down the plant, because under the circumstances, it's not in the public interest. You've already spent all this money. I mean, you built a dam. What are you going to do? Pull down the dam? You've already spent all this money. So you win, but you don't get the plant pulled down. So that takes a problem. Now, the real engine of regulation in Japan is administrative guidance. Administrative guidance, what I really want to talk about, these are suggestions by administrators. They are not legally binding. They are not legally binding, which means you can't challenge them in court. What are you challenging? They just simply advised you. But they are typically followed and obeyed. In the case of the nuclear industry, the administrator is METI or NISA. So who are the administrators? Dr. Ferguson talked about the lack of civil society, but there's more to the story than that. First of all, the regulators at METI and NISA are the same people who have for years been supporting nuclear power. Right? So you have to consider that as part of the problem. They have been for years relying on the power utilities to provide them with information. So if they see a problem, they ask the power utility to report, and the power utility reports. And we've had a number of instances where we've seen with some of the power companies in Japan that the reports aren't always completely accurate, which creates a problem. I want to skip the post-Kobe because time is running out. But Japan has what's called a lifetime employment system, and that plays a role. It's really not lifetime employment, it's for the lifetime of your employment. It's a lifetime employment system. To make this system work, the lifetime of your employment has to be short. That is to say, if you have a group of core employees who are the people who are going to run the company and going to run it in the future, they have to keep moving up. Otherwise, why would they stay? So you have to have mandatory retirement. Mandatory retirement, 58, 60, something like that. You're not yet eligible for the Japanese equivalent of Social Security. So you got to do something. What are you going to do? You have this same problem in the government, which has this same lifetime employment system. So you're a NISA person or a METI person, and now you've reached mandatory retirement. Where are you going to go? Well, it's difficult to go anywhere at any time, because if every company has a lifetime employment system, they're not hiring from outside the company, because they need to hire their own people into the vacancies. You're going to put your better people in the... If you hire someone from outside, you can't move your people up. That means you have a very restricted labor market for mid-level and upper-level executives, whether you're government or whether you're the power company. So now when you reach the mandatory retirement age at NISA or METI, where are you going to go? The only place you can go, to the company you regulated. And because you've been a government person, you have higher status, you're going to get a top-rate job. Now, once you've moved out, who moves into your position? Some guy you used to supervise moves into your position. He's now regulating you, to whom he owes loyalty obligations, because you were his mentor going up in the company. Or if you retire from the power company, where are you going to go? Into the government. The only place to go. The second thing that you need to know about the regulator is the fact that in Japan you have consensus decision making, which means everybody's got to get on board. So if you're the guy who told the group that was looking at the Fukushima plant after the Kobe earthquake to see if it was safe, and said to them, you know, back in Tokugawa times in 16 whatever it was, there was a tsunami which was stronger and higher than the wall they have there at Fukushima, and everybody else in the group is shoving you to the side, you're going to be off at the side. Or if you're the guy at NISA who, at the beginning of the Fukushima thing, said, wait a second, the problem is bigger than... He got transferred because he wasn't part of the consensus. This means that the regulator is suggesting things to people who are responsible. It makes regulation very easy, but it also makes avoidance of regulation very easy, and that is one of the problems. Also, you have the problem that Professor Carr talked about. NISA is part of METI. METI supports nuclear power, and NISA is supposed to protect it. There's talk now of splitting NISA out of METI and to put them in the environmental agency, which is, of course, the wrong place to put it, because the environmental agency is very concerned about the Kyoto Accord. Kyoto, it's Japan. The Kyoto Accords to reduce greenhouse gases. So if you're going to reduce greenhouse gases, nuclear is part of the answer. So where does that leave us after Fukushima? The answer is, well, I'm not sure where it does leave us. The courts may decide that maybe now they really do have a role. That may be one answer. The government looks like it's still supporting nuclear power. A nuclear station came online Tuesday of this week. I don't know if it's online, but it powered up again on Tuesday of this week. And the Prime Minister has indicated that he recognizes the need for nuclear. That's not criticism. That is reality. If you don't have a drop of oil and you don't have any natural gas, and you're an exporting economy, you have to get your power somewhere. So the process is, I hope you understand, very different. I'm sorry I may have taken too much time.
Thank you, Professor Goodman. We've pushing up against 2 o'clock. Some of you may have to go at that point, but I will kind of declare 10 minutes of question and answer for those who can stay, that you could, if you have questions, direct to any one of the panelists or perhaps just to the group in general.
Thanks, Dave.
Yes.
So the earthquake that occurred at Fukushima was a 9, is that right? I think.
Yeah.
Yeah.
And I think if I remember reading this somewhere, the plant was actually built to withstand a 7?
Less than 9.
6, okay, less than 9. So what are the plans for the future if it seems like they're so dependent on nuclear power to get energy because they have so few resources? How do you account for something like that that's possible it might happen again? I mean, a 9 is a pretty big earthquake. So what would it take to make it withstand something like that and have Fukushima not reoccur?
Well, I don't know what it would take technically because I know nothing about techniques, but I do know that the government is quite concerned about that issue, particularly with some power plants that are within. They're now talking about a bigger scope of area that needs to be protected because some of this fallout came out in Tokyo, which they thought was so far away nothing could reach there. And so they're concerned about how to deal with that, and they're doing studies about which plants are perhaps under qualified. How they go about doing it, I don't know. It's beyond my.
Well, this is not the first time that Japan has experienced an earthquake that's led to ground acceleration beyond what's called beyond design basis. You have design basis type of events and accidents that you plan for, and then you build in a safety margin. So what you're going to have to do is to increase that safety margin. And back in 2007, they had a huge earthquake on the opposite side of the main island, and there was the largest nuclear power plant in the world. There were 7 reactors there, got shut down, and there the ground acceleration exceeded the design basis. But there wasn't a tsunami, fortunately, and they shut the plant down for at least a few years, most of the reactors, and they brought that back up online. So there are ways of dealing with this. They've dealt with this before here in the state of Virginia, not too far from here, North Anna nuclear power plant experienced, and I was in Washington, D.C., and I felt the earthquake here. I mean, it was even more powerful here at Washington Lee. And North Anna plant, just as Professor Carr is saying in Fukushima, it shut down properly. Control rods were inserted. It was called a scram of the reactor. Reactor shut down. The diesel generators were brought up. One diesel generator had one problem, but they had enough backup power on site that the plant was brought into a safe condition very rapidly. But apparently one of the dry storage casks moved an inch or something like that. It wasn't such a big deal. But so we dealt with these events before. So it's just the extraordinary 1-2 punch of the huge earthquake and huge tsunami. And that's what we're going to have to figure out how to deal with.
One of the problems at Fukushima was that the diesel generators were down at the bottom. They weren't up on high.
It wasn't a flood-type compartment either,
Right.
so the waters could rush in.
When the tsunami came in, it wiped out the diesel generators. You were left with 18 hours of battery and no way really to get there.
But just to add to that, my understanding is, we don't know this for a fact yet, but we think that the reactors and the spent fuel pools at Fukushima maintained their integrity. And the problem was caused by the loss of off-site and then on-site power. For the earth of me, I simply cannot understand why they couldn't do what we certainly would do in this country. Diesel generators, these are nothing but the engines that go in ships.
Exactly.
They're all over the place. Hook a couple of them up to a couple of big helicopters and chopper them onto the site and start them up.
The U.S. Navy when it apparently got on site. I mean, we got some ships there quickly enough. I gave a talk a couple of months ago at a conference in D.C., and that was You know, independently of Professor Carr, that was one of my main recommendations. That's what they should do in the future, have that secure system.
So that, to me, Stephen, the answer to your question would be, and I'll defer to the tech, is not so much how you upgrade the structures, but how you deal with the loss of on-site and off-site power. And the first thing you do is put the diesel generators up where they can't be flooded. Yeah, I mean, that's one. And if your current standards call for 4 of them for a 2-unit site, put 8 of them out there. That's what.
Charles, in a boiling water reactor, you have your spent fuel stored above the reactor, right? And it's kind of within the containment, the secondary containment.
Which is a very strong containment.
Right. And in another design, the pressurized water, it's stored away from the.
Right, that's the one slide I just quickly breezed by. But right, just to quickly say what Professor Settle's saying, you basically have 2 different types of plant designs, the pressurized water reactor, boiling water reactor designs, and we're saying is exactly right. The spent fuel pools are placed differently in those 2 type of designs, and those who've argued, like Robert Alvarez and his independent group, that the boiling water reactor design is particularly vulnerable because the spent fuel pool is above grade, so they could, in theory, be drained, and then the fuel could catch on fire.
There's a question here.
Yes. To what extent is Japan pursuing alternative energies like tide and wind and geothermal? It seems that the Japanese islands are pretty well situated for all 3 of those. And is there any friction from the nuclear power industry?
Japan actually has some geothermal, power. And there's going to be, I think, a greater emphasis on that. I mean, they've had hot water at hot spring resorts, forever. And they know a great deal about geothermal. And I think you're going to see a big push to geothermal in Japan. I think Japan probably will turn away from nuclear power. It's not going to put as much into nuclear power in the future as it has. But for the near term and the midterm, I don't think they have much of an option, quite frankly. But I think you're going to see a great deal more work in the geothermal area in Japan, and I think you're going to see a great deal of work in terms of wind in Japan. There's a question as to whether geothermal and wind are as reliable. I just don't know, because you can operate the nuclear plant all the time. You operate the coal power or the diesel power all the time.
That's right.
Wind is not of that nature. I'm not sure about geothermal.
Well, of course, I'll use air quotes again, the smart grid. There's all discussion in this country and Japan, other countries about eventually we'll have smart grid, we'll have energy storage systems, so you could get the equivalent kind of base load power system out of these intermittent sources like wind, solar, and so that maybe you won't need as many coal and nuclear plants. But we're not there yet. It's going to take some time to get there.
Tom, go ahead. There was one over there too.
I just have a question. I understand that the tsunami and earthquake has been devastating in many factors economically to the people. My question is, in particular for this nuclear reactor, what are the foreseeable damages that you can guess that would happen in the next 10 years, 30 years? Not only will it affect food and water, but what other things are we expecting to see because of the nuclear power plant damage? I don't.
Well, of course, you're going to have an area that's going to be uninhabitable for a period of time. There may be some areas outside that initial ring that will also be uninhabitable because they've had a number of hot spots outside the 20-kilometer zone that they've had. So that's going to be a problem. You're probably going to have some farm production that's going to be offline, so to speak, for a period of time until they can clean up They have an enormous cleanup problem. I mean, just the cleanup is an enormous problem facing them. And one of the things that hasn't been really talked about very much is the psychological problem. I mean, there's got to be a tremendous amount of we're talking about a country that had Hiroshima and Nagasaki, and it knows what the result of that is, and there's got to be a certain amount of worry, especially from people who were in the area, who have now moved out of the area, and so on. And I don't know how you measure that in a kind of, but that's got to be a problem. If it was almost anywhere else in the world, I would look at all of that and say, my God, it's insoluble. But it's not insoluble in Japan. They'll solve it. They will solve it.
Entertain one more question?
Yeah, I was wondering if anyone on the panel, or perhaps Dr. Settle, could comment on the regulatory environment surrounding our own quake ravaged nuclear power plant. It was mentioned briefly, the North Anna plant, that's been offline since the mineral earthquake that we had in late August. And I don't know if anyone's kind of been looking at that, but I'd be interested to hear kind of what's going on with that.
Okay. I'll try that. As Dr. Ferguson and Professor Goodman said, the North Anna earthquake resulted in ground motion at the site greater than the design basis earthquake. There are two earthquakes that you design. One is called the operating basis earthquake. The other is the design basis earthquake. The OBE is the one that you design against so that the plant can withstand it and continue to operate. The design basis earthquake is so that the plant can withstand the motion, the structures, without doing damage to systems necessary to maintain safety and its ability to shut down safely. What we saw at North Anna was the fact that, as Dr. Ferguson said, a margin is designed into these structures above the design basis earthquake. Everything worked exactly as it should have. The plant actually shut down, the reactor scrammed just before the loss of off-site power. When off-site power was lost, the on-site diesel generators kicked in just as they were supposed to. One of them had to be removed from service, but they picked up the load with another generator on the site. The plant was brought to cold shutdown and is in cold shutdown now. Both the NRC and Virginia Power, Dominion, I guess it's called now, immediately began significant walk-down inspections of all of the structures and all of the systems at the plant, including the dry cast storage facilities, some of which moved several inches. But there was no damage to the integrity of those containers. The NRC has reported to the Commission that so far no damage, or at the time they reported, no damage to systems important to safety. It suffered that there was the complete inspection being done, and that only after those inspections had been done and the licensee, Dominion, reported to the Commission the results of those inspections, would the plant be permitted to start up again. There have been 4 public meetings on the issue, the last one on the 21st, in which Dominion came in and made its presentation as to why and how the plant was safe to restart. And the staff then will do its evaluation of that, or is doing now its evaluation of that presentation, and will make a recommendation to the Commission. It's anticipated that the plant should start up in late November or early December. So far, it has cost, just from the inspections and some of the remedial work that's been done, it's cost about $35 million to do that. But again, that's what we said earlier. That then becomes an issue for the economic regulator. but when you're looking at two units that I think they're about 1,000 or 1,100 megawatt units, you're looking at 2,200 megawatts of power. If you had to replace that, you're looking at billions of dollars. So anyway, that's the process, and so far everything looks as though it's working. You know, that the plant withstood everything. And to me, that's the single best answer to the NRC's generic process they've got going on, and the recommendations in the task force report. You know, it's like the flooding in the Midwest. What more do you need? So that's a long-winded answer, but
No, thank you.
I'd like to make one brief comment about the Japanese courts, because I told you about the Manju 2 decision, not unreasonable and so on. Fukushima may change things. If you're familiar with Minamata disease, Minamata disease was a disease that showed up in Minamata, Japan. It's caused by mercury in the water, which is ingested by the fish, and then the fish in turn are eaten by people. In the Minamata disease was one of the 4 big pollution cases they talk about in Japan. In the Minamata disease case, when that case was brought, it's been reported that the lawyers who brought the case told their clients they didn't have any chance of winning. Clients brought it anyway because they wanted the publicity to get the word out about the problem, and so on and so forth. As that case went along, they had no chance of winning because they could not meet the burden of proof, which was a very stringent burden of proof. As that case went along, public opinion in Japan about the disease became pretty clear, and the public was very angry at the company that was involved, and actually angry at the government that had allowed the effluent to go into Minamata Bay and cause what had happened. And the court changed the burden of proof. Now